So here's a question we'll answer today. Taxes that are being collected by somebody, are those taxes considered debts under the FDCPA, the Fair Debt Collection Practices Act? And as a sort of bonus thing, we'll look at one technique of research. And this is a technique where we start off with a case and it says, hey, in the past, there was a similar case. And so one simple technique is you read this case and then you go into the past and read the previous case. And sometimes that gives you sort of the whole picture of what's going on. So let's start off with this case. It's from the 11th Circuit, 2020. That says do not publish, which just means it's not binding on the 11th Circuit, but it's pretty persuasive. And this was a case involving a number of claims, and there are a number of issues that aren't particularly relevant to us. But one of the claims was that there was somebody that was sued that was collecting back taxes. And those back taxes would be considered a debt under the FDCPA. Well, that was the question. And the district court said they're not debts under the FDCPA. And so here we have the 11th Circuit saying an obligation to pay that arises solely by operation of law is not a debt covered by the FDCPA. It cites to this affinity management services case out of the 11th Circuit 2016. And they say because tax obligations do not arise from business dealings or other consumer transactions, they are not debts under the FDCPA. Then they cite to a Second Circuit case and also to this 11th Circuit case from 2010. Now, that gives us the answer. Okay, the 11th Circuit says, at least in this non-binding opinion, that taxes are not debts under the FDCPA. So if somebody's collecting, they're calling me, they're putting stuff on my credit report, they're writing me letters, and they are a collector, and I think they violate the FDCPA, but they're collecting tax debt, that's not going to be covered by the FDCPA. But, this doesn't give me just a tremendous amount of analysis here. So one way to research is you go back. So here's a case and you go back in time and say, well, let me go read that previous case. So let's go read this affinity management. Now we could also do this Beggs versus Rossi, but we'll just do this affinity management just to illustrate this. So this 2016 from the 11th Circuit really has to do with a homeowner's type of squabble here, HOA. So here we see the district court erred in concluding the HOA Homeowner Association fine at issue is not a debt. So the district court said, you know what, you got fined by the HOA. It doesn't matter what the details are. You didn't cut your grass or you had a car parked in your front yard, whatever it is. That fine, the district court said not under the FDCPA. But the 11th Circuit said, actually, you're wrong. It is under the FDCPA because it arises out of a transaction that was consumer in nature. That is, you're living in your house. So let's kind of flip through here and we'll get to the part. The facts aren't particularly relevant for us because we're just trying to get what is the essence of the law here. Why did that previous case, this Dressler case that we looked at, why did that cite to this affinity case? So here we go. Whether the HOA fine is a debt under the FCCPA. Now, the FCCPA is the Florida version of the FDCPA. It's the same law for this purpose. So let's look and see what we've got here. So up at the top of this page, they say, look, you've got to make this threshold showing that the money being collected qualifies as a debt. Now, obviously, it's money that's allegedly owed, but that doesn't mean it's a debt under the Fair Debt Collection Practices Act. Not every person collecting is a collector under the FDCPA. Not every debt being collected qualifies as a covered debt under the FDCPA. So they say the mere obligation to pay does not constitute a debt under the FDCPA. Well, you'll remember that from the case from 2020 that we just looked at. Instead, under both statutes, talking about the FDCPA and the Florida version, a debt is any obligation or alleged obligation of a consumer to pay money, here's the key, arising out of a transaction in which the money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, or household purposes. So the 11th Circuit says, well, here's how we sort of organize this in our mind. We say there are three elements here. Number one, it's a consumer arising out of, or let me back up, the obligations of a consumer. So we're not talking about a business here. It's a consumer rising out of. Number two, a transaction which money, property, insurance, or services at issue. Then number three are primarily for personal, family, or household purposes. And they say in this HOA thing, we're going to focus on element number two, this consumer transaction here. All right, so let's look at this. They say when the transaction creates an obligation, a debt is created, and that will be covered. So then this is the way courts work. They say, let's look back into the past, kind of see what we did in the past, and that will give us guidance. So they say, well, here's a case called Brown versus Budget Rent-A-Car. Now we could go look at that if we really wanted to do this in depth. And it says, even if tort-like conduct triggered an obligation to pay, but that obligation arose from a consumer contract rather than solely by operation of law, the obligation is covered. All right, so what does that mean? It just means if something happens and like there's a car wreck and you're sued over that, or somebody claims you owe money because of that, then we look and see, well, was there a contract that obligation arose out of? So here we go in Brown. There was a rental agreement. So you go to, Budget Rent-A-Car, Enterprise Rent-A-Car, and then you're in a wreck. And because you signed that rental agreement, the rental company says you owe us money now because of that wreck. Well, that arises out of the consumer transaction. And so they say driver crashed and damaged the truck. He had ridden pursuant to an agreement with the rental company. After the company tried to collect money from him, he brought an FDCPA claim, and they say, look, the rental car company's assertion the driver's obligated as a result of a consumer transaction suffices to bring the obligation within the ambit of the FDCPA. In other words, within the coverage of the FDCPA. And then they mentioned this Oppenheim case. That's a 2010 case that involved PayPal. So a guy has a PayPal account. He gets some money. Turns out it's fraudulent. And under the terms of his PayPal agreement, he has to refund that money. So they say utilize PayPal services and was under a contractual obligation to repay the money after it was determined the payment made to him was fraudulent. The payment obligation constituted a debt. All right, so let's look now at the other example here. So they say, by contrast, we've held where the obligation to pay arises solely by operation of law. In other words, there's no contract. The obligation is not a debt under the FDCPA. So here's Hawthorne versus Mack adjustment. So it's not a debt if it did not arise out of any consensual or business dealing. Now, don't be sort of distracted by the business dealing. This is not saying business debts would be covered. It's just saying, have you done business with this company? Like I go and rent a car on vacation from Enterprise. Well, I've done business with them, but it's still a consumer transaction. So they say a tortfeasor. So a tortfeasor is the person that supposedly did something wrong, like ran the red light, for example, brought an FDCPA action against a company attempting to collect damages resulting from the tortfeasor's, and we'll just put alleged negligence. So I run a red light and cause damage to a car, and then a collection agency starts trying to collect those damages from me. Well, if I don't have any relationship with that person, or there's no underlying contract that all this arises out of, then it's not going to be covered. They said because no contract, business, or consensual arrangement existed between the tortfeasor, it's the guy that ran the red light, and the injured party, we held the obligation to pay for damages arising out of the accident did not constitute a debt. So now that might make you think, if you only had read that case, that it's the person that ran the red light and the person that was injured. It has to be a contract, which you very rarely would have. But that's not the case. That's just one example. Now, we've had other examples where we see there's a rental agreement and there's damage, and now that arises out of it. So now we have the court trying to pull all this together and say, let's give you a unified rule here. In essence, our jurisprudence, that just means our cases, in this area of law can be distilled or summarized into the principle that FDCPA debts arise from actual contracts. In other words, I have a contract with Enterprise. I have a contract with the hospital, okay, to do surgery on me or take an x-ray or whatever it may be. And now somebody's collecting that. Well, that collection arises out of that contract. But if it's just and they call it a social contract, that would just be, I'm not supposed to run the red light and endanger you. Well, if I do that and you start collecting that money against me, that's not going to be covered by the FDCPA. So I wanted to share this with you again for two reasons. One, just say the 11th Circuit views taxes as not being debts covered by the FDCPA. Now, that's not binding, that case we read, but that seems to be the trend or the direction they're going. But then I wanted you to see sort of what's the mindset behind this, case law, and we get a case here, and then in the future it cites this case, or we have a case and it refers back to a previous case. Well, really, to fully understand this area of the law, you've got to read all these cases. Okay, so the lawyers watching this will understand this. Somebody will say, well, here's a case that proves everything. We're like, whoa, not so fast. Let's see, what are the facts of that case? What does it rely on? What happened after that case? And then we got to read all the other cases. So to give you an example, when I started doing FCRA work, Fair Credit Reporting Act work, in a serious way, this is about, I guess 2003. I mean, I'd been suing before that, but where I said, I'm going to make a really concerted effort here. I didn't read one case. Actually, I printed out every case from the 11th Circuit involving the Fair Credit Reporting Act. So those were the appellate court cases, like what we're reading right now, but also the district court or the trial court decisions. And I remember my secretary put this together. It was like two big notebooks about that thick. I just sat there. And I mean, not all at one time, but, I'd spend like an hour, 2 hours a day just reading through every single case. And what you do is you start to see patterns. You see, oh, now I understand why the court's saying this. Or, wow, here's a mistake that's just so often repeated here. Don't make that mistake. So if we really want to understand the law, we've got to sort of get the full picture. You take a case and you say, well, what came after it? Well, what came before it? And then how do all these things connect? So hope you found that helpful. We'll continue to do these if you're getting value out of them. And hope you guys have a great day. Okay, have a good one. Bye-bye.